Hey, welcome to today's video. I'm Rick Chapo with DMCAAgentservice.com. So today we're taking a look at the DMCA Expeditious Removal requirement. The what? This is a part of the compliance process for the DMCA. So if you are a website or an app owner, you can take advantage of the DMCA to gain immunity from any copyright infringement claims based on content uploaded by one of your users. So if you have, let's say, a website and you write a long blog post and somebody doesn't agree and they go out and they copy an article from another site that counters your argument and they post it as a comment to your blog post, is that copyright infringement? And the answer is probably. Now, the question is, can you as the website owner be held liable for that infringement because your user posted it? And the answer is no. You have immunity under the DMCA. It's called the DMCA Safe Harbor provisions. Now, this immunity comes with a catch. Big surprise, huh? There's always a catch. And in this case, the catch is you have to follow a compliance process for handling a DMCA complaint and so on and so forth. And the expeditious removal requirement is part of that compliance process. So let's just dig into it. The language is found in section 512C, subsection 1, subsection A, subsection 3. Yes, 4 subsections there. This is why people hate the law. And the language is in reference to what duty does the website or app owner have. And as you can see it right there, the duty is upon obtaining such knowledge or awareness, acts expeditiously to remove or disable access to the material. Now, generally, the way that this works is that you would receive a DMCA takedown notice, and it's going to tell you, hey, somebody's ripping off my content and has posted it to your site without my permission. And then you have knowledge, and so you must act expeditiously to remove it. Well, what does expeditiously mean? The code doesn't say. If we look at a definition, it means with speed or efficiency. Yay. That's not particularly helpful. So where do we go from there? And the answer is lawyers do what lawyers do, and they start suing over it. Now, in truth, there aren't very many cases on the issue, but there are a couple. And so the first one was actually Perfect 10 versus Google. And in this case, Google argued that it should be immune from DMCA or from copyright infringement claims. But the court said no. And the reason was rather obvious. Perfect 10 was an adult content site, and so they produced adult images. In this case, was way back, really before video was prevalent. And so Google was grabbing the images and creating thumbnails. Google does this all the time. And Perfect 10 said, hey, that's copyright infringement. And Google said, no, it's fair use. It helps people search for content online. And the court ultimately agreed with Google. And that's why we have thumbnails today. This is actually the court that established that, the right to have thumbnails and that they're not copyright infringement. See all the interesting things you learn. But Google also tried to make a DMCA claim, and the court just kind of threw it out, as they very much should have. And the reason for that was that when Perfect 10 started submitting complaints, Google took 7 months to remove the content. So I think we can all agree that 7 months probably isn't expeditious. I'm not even sure why Google made the argument. I think they were just throwing things against the wall to see what would stick. But obviously, that didn't go very far, and it's not very helpful in telling us what expeditious actually means. However, the VO cases, they are. In the VO cases, copyright owner sued, claiming that the company, amongst other things, had not expeditiously removed content as required by the DMCA. And the court looked at the situation, and they found that VO had removed the content within a day or, quote, couple of days, end quote, and that this was sufficient to meet the expeditious removal requirement. And so many people have latched on to the, quote unquote, couple of days and have suggested that means that 48 hours is sufficient. Lawyers use that standard. We use it. Pretty much everybody does these days. It's never really been countermanded. And so that's where the 48-hour standard came from. And we haven't really seen too much that has countered that since then. There was a case called Square Ring versus Ustream. Now, in this case, it's a bit of a unique situation because Ustream was taking content from Square Ring and streaming it. So it was a live event, if you will. And so waiting 2 days, giving Ustream 2 days before they had to take down the content, provided them a huge benefit. If you have streaming content, people want to see it, then it was a live event. So if you think of a sporting event, let's say it's a pay-per-view boxing match or something of that sort. Well, you want to watch it when it's occurring. And if Ustream is given 2 days to not take it down, well, the damage is already done. Most people would have watched it within that 2-day period. And so the intent of the DMCA is somewhat defeated. And so anyway, Square Ring sued, and they said that, waiting a couple days was not expeditious removal based on the facts of the case. And the court issued a ruling, which has caused a lot of confusion because you have to understand something about the law to understand what the ruling means. A lot of people say that Square Ring versus Ustream, the court issued a ruling saying the 48-hour removal requirement is too long and that it should be much shorter. And that's not what the court ruled. So what happened? Well, in a civil lawsuit, you have the suing party, known as the plaintiff, and the defendant. And once the complaint is filed, an answer is filed by the defendant. And at that point, they pursue discovery. And discovery are the exchange of written questions that each party has to answer under penalty of perjury, depositions where oral testimony is taken, the exchange of documents and things of that sort. Once the discovery is completed, one or both parties can then move for what's known as a motion for summary judgment. And what this motion basically says is that based on all of the evidence before us and the law, one of the parties does not have a viable either case or defense, and the court should rule as a matter of law that one party wins. And now a motion for summary judgment can be easily defeated where a question of fact exists. So if a court says, well, that's all great and all your argument's wonderful. However, this aspect of the case is really a question of fact. So we're going to let it go to trial. Now, the person or persons who decide a question of fact, it's not the judge, it's the jury. And that's why we have lawsuits. So, did a party meet its obligation? Did so-and-so, really strike this other person? Those are decisions that a jury decides. Now, in Square Ring versus Ustream, the court ruled against Ustream. But the court didn't say that the 48-hour expeditious removal period was insufficient, that it needed to be shorter. All the court said was that it was a question of fact, meaning that it needed to be presented to the jury, and the jury could then decide. Now, then, I don't even know what the jury decided, but that jury decision would only be applicable in that case. It's not a standard for the rest of the cases. So if you had a subsequent case, the decision in Square Ring versus Ustream is not binding on your case. However, it does raise a very important point, which is the expeditious removal requirement, in my opinion, is 48 hours is a decent standard, but you have to look at the surrounding evidence, the situation, if you will, and determine whether that really is sufficient. So let's look at two scenarios where this might play out. Google receives something like 90 million DMCA takedown notices a year. That's a huge number. And even if they filter out a good number of them just using computer software, well, there's still going to be millions that people are going to have to actually review. Somebody at Google is going to have to actually look at. Okay, that is a buttload. That's a Latin term, buttload of complaints and work. And so requiring Google to process every takedown notice within 48 hours is ludicrous, and courts have agreed. These are not published opinions, but Google has always been given more time because, that's just insane, the number of complaints they have. So, from what we've heard, it's, Google's been given up to a week, 2 weeks in some cases, to process a complaint because they're just to require them to do it all within 48 hours would be insane. Now, on the other hand, if you look at, again, we go back to Square Ring versus Ustream. Well, if somebody is, let's say, publishing something on YouTube and it's a live stream of a live sporting event and it's copyright infringement, well, that 2-day period is too long because, again, if you want to see that event, let's say it's a UFC fight and it's on Saturday night. Okay, well, nearly everybody's going to want to see it live. So if I pop onto YouTube and there it is and I watch it, the fact that YouTube takes it down 2 days later has almost no effect on me. It doesn't benefit the copyright owner at all because, literally 2 days later, will some people still want to see it? Sure. But the vast majority of people are going to want to have watched it live. So in that case, immediate removal would probably be the standard. Now, for most people out there, if you have a blog or website, some kind of static website or app, the 48-hour period is probably going to be fine. So don't worry about it too much. But nonetheless, it is an issue that you want to make sure you understand, and you want to review your platform, determine if it should be a shorter or longer period. So anyways, that's it for the DMCA expeditious removal requirement. If you have a website or an app and you're trying to comply with the DMCA, make sure you understand it, and you have a policy for your site or app that you follow every time, so that you're consistent, and you can hopefully defeat any kind of court challenge. Again, complaints in this area are very rare, but if you abuse it, if you have a website that gets 5 complaints a year and you take 3 weeks to process those complaints, you're setting yourself up for failure. So anyways, that's it for today's video. Thank you for watching. Have yourself a good one.